Hello and welcome to our today's lecture on Section 80, 81, 82 and 83 of Indian Penal Code. Section 80, Accident. Accident in doing a lawful act. Nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge in the lawful act in a lawful manner by lawful means and with proper care and caution. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offence. Principle. Section 80 gives statutory recognition to the common law doctrine of mens rea, that there can be no crime without a criminal intention. This is to say, to constitute a crime, both act and intent must go together. Actus not facit ream, nisi mens sit rea. In other words, no act is per se criminal unless the actor did it with criminal intention. As per Section 80, a person may be exempted from criminal liability if he can prove that the act was done accidentally without any criminal intention, and accident occurred while doing a lawful act with due care and caution. The elements which a person is required to prove in the defense of accident or misfortune are as: number 1, accident or misfortune. An accident in ordinary parlance means an event that occurs without one's knowledge and beyond expectations. Thus, an accident is an incident that takes place out of the ordinary course of events which no man of ordinary prudence could anticipate or provide against. Likewise, a misfortune is an accident with harmful consequences resulting in injury to another. For example, A workman, while throwing sand from a rooftop, gives proper warning, but B, a passerby, is nevertheless killed. The act is accidental and one for which A is not liable. But if A takes up a gun, not knowing whether it's loaded, points it in spot at B, pulls the trigger, and B is shot dead, B's death is not accidental, since there was want of proper care and caution on the part of A, and A will be liable for B's death. However, if A had reason to believe that the gun was not loaded, B's death would have been accidental, without criminal intention or knowledge. The essential element of accident as a defense is absence of criminal intent of the doer of the act. For example, where two wrestlers were wrestling, one of them sustained serious injuries that ultimately caused his death. The other wrestler was charged of an offence under Section 304A of the Indian Penal Code. This is Tanda versus State, 1950. The High Court of Allahabad held that the injuries were accidental, being unintentional, as there was no evidence of any foul play. Hence, accused was not liable. In lawful act in a lawful manner by lawful means, if an act is illegal, it would not afford a ground for exemption from criminal liability. For example, A, intending to kill B, mixes poison in his food, but C, his cousin, takes the food and dies. Here, C's death is an accidental act in the sense of being an act of misfortune. However, A is not exempted from killing C, despite the fact that he never intended to kill him, since the act of killing a human being is an illegal act. A is as much liable for killing C as he would have been had B taken the poison. Proper care and caution. If an act is done without proper care and caution, the accused is not entitled to the benefit of Section 80. To fire a gun in a marriage procession is a reckless act and is not given the benefit of Section 80. There is no intention, but there was lack of due care and caution. Let's have a look at some case studies. State of Orissa versus Khora Ghasi, 1978. A cause death of D by shooting arrow under the bona fide belief that he was shooting that arrow at a bear which had entered into his field and was destroying his maize crop. Death was held to be the consequence of accident. Rajaram versus State 1977. A fired his gun at B, his assailant, to defend his person, but B escaped injury and shot hit 4 other persons, one of whom died. In the absence of evidence that the accused A intended to cause injury to the injured person, it was held that he was entitled to protection under Section 80, 96 and 100 of the Indian Penal Code. Section 81. Necessity. Act likely to cause harm, but done without criminal intent and to prevent other harm. Nothing is an offence merely by reason of its being done with the knowledge that it is likely to cause harm, if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Here is an explanation. It is question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that it was likely to cause harm. For example, A, the captain of a steam vessel, suddenly and without any fault and negligence on his part, finds himself in such a position that before he can stop his vessel, he must inevitably run down a boat. B, with 20 or 30 passengers on board, unless he changes the course of his vessel, and that by changing his course he must incur risk of running down a boat, C, with only 2 passengers on board, which he may possibly clear. Here, if A alters his course without any intention to run down the boat C, and in good faith for the purpose of avoiding the danger to the passengers in the boat B, he is not guilty of an offence, though he may run down the boat C by doing an act which he knew was likely to cause that effect, if it be found as a matter of fact that the danger which he intended to avoid was such as to excuse him in incurring the risk of running down the boat C. Principle. Section 81 of the Code grants immunity to a man from criminal charge with respect to acts committed under compelling circumstances forced by necessity. In the view expressed by Stephen that it's just possible to imagine cases in which the expediency of breaking the law is so overwhelmingly great that people may be justified in breaking it, but these cases cannot be defined beforehand. The justification for exemption from criminal action on the ground of necessity has been well summarized by Lord Mansfield in the celebrated case of George Stratton, 1779, in the following words. Whenever necessity forces a man to do an illegal act, forces him to do it, it justifies him, because no man can be guilty of a crime without the will and intention of his mind. It must be involuntary. A man who is absolutely by nature necessity forced, his will does not go along with the act. Thus, an act which would otherwise be a crime may in some cases be excused if the person accused can show that it was only done in order to avoid, and which, if they had followed, would have inflicted upon him or upon others whom he was bound to protect inevitable and irreparable evil. That no more was done than was reasonably necessary for that purpose, and that the evil inflicted by it was not disproportionate to the evil avoided. Extent and scope. The defense of necessity finds place in the penal laws of almost all the countries influenced by the common law. In Queensland, Western Australia, certain European penal codes as that of Germany, as well as in the Soviet Union and the United States of America. The defense does not give blanket immunity from liability in all circumstances. It is available only in exceptional cases like, number 1, where the act was done in order to avoid consequences which could not otherwise be avoided, and which, if they had followed, would have caused irreparable damage. Number 2, that no more harm was done than was necessity for that purpose. And number 3, that the evil inflicted was not disproportionate to the evil avoided. Number 4, ingredients. To attract the provisions of this section, these conditions must be satisfied. Number 1, want of criminal intention. The act constituting the offence must have been done without criminal intention to cause harm. Section 81 stipulates the absence of criminal intention, but not the criminal knowledge. That is, the doer knows that what he is doing is an offence, but he does so without criminal intention. Number 2, the act must have been done in good faith for the purpose of preventing or avoiding other harm to person or property. The main principle on which this section is based is that causing of lesser evil in good faith may be justified to prevent greater evil either to persons or property. All measured which may become necessary on occasion of contagious diseases, earthquakes, famines, cloudbursts and tsunamis, etc. are covered by this section. Number 3, the harm must have been done in order to avert a greater harm. Although the word greater evil or lesser evil are not specifically used in the phraseology of section 81, but the explanation to this section makes it clear that it is a question of fact to be decided in accordance with each case as to whether the harm to be prevented or avoided was of such a nature as to justify or excuse taking the risk of the act. Case studies: Queen versus Dudley and Stevens, 1884. In this leading English case, the accused and Stevens were steamer. Their ship capsized in a storm. They, along with a boy of 17 years of age, managed to float on a wooden plank. They continued to drift for many days without food and drinking water. The land being more than 1,000 miles from the mid-sea where they were drifting, they thought on 20th day that the only alternative to survive from death by starvation was to kill the boy and eat his flesh for 4 days, when they were rescued. On being prosecuted for murder, they took the defense of necessity and argued that there was no other alternative for survival. The court rejected their plea and convicted them both for murder, and they were sentenced to death. The court ruled that the defense of necessity cannot be extended to the extent of causing death of a person in any circumstances. The Crown, however, reduced their sentence to 6 months' imprisonment, keeping in view the tragic circumstances in which they were placed for such long duration. The court, after discussing at length various issues involved in the question of conservation of a man's own life in extreme cases of hardships, laid down following principles. Number 1, self-preservation is not an absolute necessity. Number 2, no man has a right to take others' life to preserve his own life unless it is in self-defense. Number 3, there is no necessity that justifies private homicide, that is, to conserve one's life as distinguished from public necessity or even necessity when it is a justification. In Dhania Daji versus Emperor, 1868, the accused mixed poison in his toddy, knowing that it is injurious for human consumption, but with the intention of detecting the unknown thief who was in the habit of stealing the toddy from his pots. Some soldiers purchased toddy from an unknown vendor and on consuming it suffered injury. The accused was held guilty under section 328 IPC, and his plea that he mixed the poison in toddy out of necessity to detect the toddy thief was not accepted by the court. Section 82, Infancy. Act of a child under 7 years of age. Nothing is an offence which is done by a child under 7 years of age. This section relates to infancy as a defence. A child below the age of 7 years presumed to be dolly incapable, that is, incapable of committing an offence. Blackstone has explained the reason for exempting infants from criminal liability in these words. Infancy is a defect of the understanding, and infants under the age of discretion ought not to be punished by any criminal prosecution whatsoever. In legal sense, both boys and girls were held to be infants under the age of 7 years and immune from punishment. The scope of immunity granted under this section is wide enough to exempt a child not only from prosecution for offences under the Indian Penal Code, but also from offences under the special as well as local laws, as explained under Section 40 of the Code. Absolute immunity. In India, child below 7 years of age is considered as incapable of distinguishing between right and wrong, and so no criminal responsibility should be fastened in law for his deeds. Merely the evidence of the age would be a conclusive proof of the innocence of a child and would ipso be an answer to any charge against him. Case studies. Marsh versus Loader, 1863. In this case, defendant caught a child while stealing a piece of wood from his premises and hand over into custody. Since the child was under the age of responsibility, he was discharged. Section 83. Act of a child above 7 and under 12 of immature understanding. Nothing is an offence which is done by a child of 7 years of age and under 12, who has not attained sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion. Section 83 provides qualified immunity to a child above 7 years and under 12 years of age. In other words, in case of a child above 7 years of age but under the age of 12 years, the incapacity to commit an offence will depend on his maturity of understanding to judge the nature and consequences of his conduct. Ingredients. These conditions must be satisfied before taking the defence under Section 83. Number 1. An act done by a child above 7 years but under 12 years of age. Number 2. The child must not have attained sufficient maturity of understanding to judge the nature and consequences of his conduct. Number 3. Incapacity must exist at the time of commission of the act. Scope. Section 83 deals with the cases of qualified immunity because a child above 7 but below 12 years of age is presumed to be possessed with maturity of understanding and capacity to commit a crime. However, the presumption is rebuttable, and the burden to rebut this presumption lies upon the defendant, and child between 7 to 12 years of age is qualified to avail the defiance of doli incapa if it is proved that he has not attained sufficient maturity of understanding to understand the nature and consequence of his conduct on that occasion. Case study. The test of qualified immunity under Section 83 is dependent upon 3 factors. Number 1, the nature of the act done. Number 2, subsequent conduct of the offender. Number 3, demeanour and appearance of the offender in the court. Musamat Aimona, 1864. The accused, aged about 10 years, slept with her mother-in-law on the night before she committed murder. Her husband, aged about 19 years, slept with his brother in another hut, but in the same homestead. In the early hours of the fateful day, the mother-in-law woke up the accused and told her to go about her household duties. Shortly after this, the accused was seen running out of the house, and her husband was found brutally wounded on the neck. She hid herself in a field and could be found in the afternoon. It could be inferred from the circumstances of the case and her conduct that she was possessed with sufficient degree of criminal intent so as to justify her conviction. In Ula Mahapatra, 1950, the accused, a boy of over 11 years but below 12 years, picked up a knife and threatened to cut the deceased to pieces and did actually kill him. It was held that his action could lead to only one inference, namely that he did what he intended to do and that he knew all along that one blow inflicted with a knife would effectuate his intention. He was sent to reformatory school for 5 years. In Marimuta, a girl aged about 10 years picked up a silver button and gave it to her mother. The girl was not held liable for theft because the circumstances did not disclose that she had attained sufficient maturity of understanding to judge the nature of her act. Dear viewers, with this we come to the end of our today's lecture on Section 80, 81, 82 and 83 of the Indian Penal Code. Hope you enjoyed it and thank you for watching.